everyone, Jai Hind and welcome to the platform of Shri Ram's IAS once again. And in today's session, we'll be discussing the second part of the Constitution, and that is Citizenship of India. Along with me, my name is Bhavar Singh Surai. I'm ex-NDA 115th course, as well as I have qualified the civil services exam as well. But before moving ahead, let me tell you that we are offering you the free one-on-one mentorship at Shri Ram's IAS. For this, you have to do only very simple thing, and that is you have to fill out the Google form that is given in the description box, and wherever you are facing any difficulties, wherever you are facing any kind of doubts in your preparation for the civil services, you can avail this mentorship with our trained mentors at the Shri Ram IAS. And that is, again, it is completely free of cost. All right. So now moving back to the citizenship of India, and that citizenship that is governed by the Constitution of India. Now, what is the citizenship? When it comes to the citizenship is basically a kind of the membership of the state. It is a membership of the state which establishes a legal bond that is between individual and the nation. When it comes to the citizenship, it confers you certain rights, and the rights are basically the political rights, civil rights, as well as fundamental rights which are conferred to the citizen of any nation, or according to the Indian Constitution, the citizen of India. So as a citizen of India, you get certain rights and protections. That is, you get the political right to political participate, as well as you get the rights to cast your vote, that is the voting rights. You get the civil liberties as well as legal protection which are guaranteed by the Court of India or the Judiciary of India. Alright, you also have the access to fundamental rights which have been guaranteed by the Constitution. So that is, or what is the Constitution it means. Alright, when we talk about the people who are residing in any nation, in any country, so the people could be the citizen, or they could be as well aliens. All right, now the aliens are basically not those people who are, or those suspected individuals which are outside our earth system. All right, so not that alien. Over here, alien means that they have limited rights. They are actually foreigners which do not have the citizenship of that particular country. So they have limited rights and no political participation, whereas as a citizen of any country, you get the full rights under the Constitution of that country. Now, when we talk about the citizenship of India, so it has been guaranteed by the Part 2 from Article 5 to 11 of the Constitution which are there. Alright, and over here between Articles 5 to 11, you will find that over here the principles of the citizenship are basically those which governs or which governed the people when the India got independence, all right, or at the time of the commencement of the Constitution on 26 January 1950. So these are those provisions, and they established the initial criteria for the Indian citizenship. Later on, that right or the right to modify the citizenship or to have a legal document related to citizenship, or guaranteeing the citizenship to the future generation, that was left to the Parliament, and Parliament using that right has enacted the Citizenship Act of 1955 that was later on amended at different intervals, and this had been enacted under Article 11 by the Parliament of India. Alright, and again let me tell you that in India only Parliament governs the citizenship, and it can modify the Citizenship Act of 1955. Now these are the articles from 5 to 11, just an overview. Article 5 deals with citizenship at the commencement of the Constitution. Article 6 deals with the rights of citizenship for migrants. They came from the Pakistan. Article 7 is about the rights of person who migrated to Pakistan. And Article 8 is about right of person of Indian origin who are residing in another foreign country, as well as Article 9 is about the person acquiring foreign citizenship and they are not to be the citizens of India. Article 10 is continuance of citizenship rights, and then Article 11 is that the Parliament is empowered to regulate the citizenship by law, or it can make any law that will regulate the citizenship in India. So these are the different articles. Article 5 is basically about the citizenship at the commencement of the Constitution, and it said that any person will be deemed as citizen of India on 26 January 1950 if he is the person had domicile in the territory of India, all right, there is a domicile requirement, or he is born in the territory of India, all right, along with this, or either parent born in India or ordinarily resident of India for 5 years immediately preceding the commencement of the constitution, then he would be deemed as citizen of India on 26 January 1950. Now, Article 6 deals with the migrants that they came from the Pakistan. Now, there are two conditions over here. That is, before 19th July 1948. If they came to India before 19 July 1948, they would be conferred with automatic citizenship, and they have to come before, or they would have come before 19 July 1948. But afterwards they have to register. Registration is required with the prescribed authority for the citizenship eligibility, and that was the condition over here for the migrants who came from the Pakistan. All right, so there were millions who crossed the borders during India-Pakistan partition, and Article 6 provided for the framework where they could be given a legal citizenship when they entered India or they migrated to India. Now, Article 7 is about reverse migration. When we are talking about reverse migration, they are those people who migrated to Pakistan after 1st March 1947. But they were not entitled to be citizen of India. When we are talking about the exception provision, they could regain the citizenship if they returned to India under permit for resettlement, or obtained permit for permanent return, and or registered with the prescribed authority. Then they could have, or they could be given the citizenship of India. Now, Article 8 is about the Indians which were there in abroad. There were certain countries that were there, all right, like for example, Kenya, Uganda, Fiji, Mauritius, Myanmar, and other nations where we had the Indian diaspora. So for them, there was that the Indian person of origin who is residing outside India could register as citizen. Over here, the process was defined that the registration should be at the Indian consulate in the country of residence and subjected to the prescribed condition, and then they could be the citizen of India at the commencement of the constitution. The Article 9 to 11, that is 9, 10, 11, had laid down the regulation framework for the citizenship to be governed after the commencement of the constitution. Over here, Article 9 says that if a person voluntarily acquires a foreign citizenship, all right, a person voluntarily acquires the foreign citizenship, that will result into automatically loss of his Indian citizenship, because we do not have dual citizenship. All right. Article 10 is about the continuance rights. That is, every person recognized as citizen, he continues as such until provision of law terminates that citizenship. And Article 11 gives the Parliament the power to regulate the citizenship as per the laws, all right, and it can regulate, the Parliament can regulate the acquisition, termination, and all the matters that are related to the citizenship. Now, on the basis of the power that is conferred to the Parliament, according to Article 11, there was Citizenship Act of 1955 that was, it was legislated as well as it entered into the laws of India. Over here, there are different things which have been mentioned, that is the methods of acquiring or obtaining the Indian citizenship. Then the methods where the citizenship can be lost or it could be terminated, and as well as along with this, there are additional provisions and procedures which are mentioned in the Citizenship Act of 1955. Now, there are 5 modes under which the citizenship of India could be acquired. The first mode is by birth. So, any person or every person who is born in India on or after 26 January 1950, alright, subject to conditions regarding parent citizenship status, he is or she would be citizen of India if you had been born in India. Right now, the condition is that either of the parents should be Indian, and then if he has been born in India, so he would be considered as a citizen of India. Now, by descent, where a person who is born outside India, if at least one of the parent is Indian citizen at the time of the birth, so then that person can claim the citizenship of India. Alright, along with this, by registration, where the person of Indian origin or the spouses of Indian citizen and minor children of such citizens which are registered, they can register themselves by the registration and they can have the citizen of India by the process of registration, then by naturalization, where the foreigners who have resided in India for 11 years of the at least 14 years, alright, of the last 14 years, they may apply for the citizen. So in the last 14 years, they must have resided in India for 11 years and 1 year continuously before applying for the citizenship. Then they can have, the foreigners can also have the citizenship of India, and this is the procedure. And the another procedure is by incorporation of the territory. Whenever new territory becomes part of India, the residents are basically given the citizenship of India automatically, and these are the 5 modes under which the citizenship of India can be acquired: by birth, by descent, by registration, by naturalization, and by incorporation of the territory. And there are 3 modes through which the citizenship can be taken away from any person. It is by renunciation. Renunciation is when a person is voluntarily surrendering his Indian citizenship. So a person who is voluntarily surrendering his Indian citizenship, alright, so he ceases to be citizen of India from the date of the declaration. This happens when a person takes citizenship of any other foreign state. Then we have termination. Termination is automatic loss of the citizenship upon acquiring of the citizenship of any other country. Now, where renunciation is voluntary, termination is not voluntary. Alright, if a person does not gives up his citizenship voluntarily, then his citizenship can be taken away if he acquires the citizenship of any other foreign country voluntarily. So in that condition, his Indian citizenship is taken away whenever he takes up the foreign citizenship, and that is obtained voluntarily, because we do not have dual citizenship in India. And there is deprivation as well. Deprivation is where the government revokes the citizenship of India. Alright, that is when there is false or fraud representation for the acquisition of the citizenship, where a person has tried to get the citizenship of India by registration, by naturalization, and he has obtained that citizenship by fraud or forgery. Alright, and there is disloyalty to the constitution or unlawful trading with enemy during war. Alright, so in that condition, the government can take the citizenship of the citizen of India by the process of deprivation. So there are 3 methods or modes through which the citizenship of India can be taken away: by renunciation, by termination, as well as by deprivation. Alright, now when we talk about India, we have adopted the single citizenship model, where we have single citizenship, and that is of India. Alright, that is similar to the United Kingdom's constitution. We have taken single citizenship from the UK's constitution. Alright, there are no state citizenship. It promotes the national unity as well as ensures equality across all states, and every citizen enjoys the same set of rights all throughout the country. And this citizenship model, single citizenship, is in contrast with the USA model, where in USA there is dual citizenship, that is both of the center or the federation as well as of the state level. But we have adopted the singular national identity or citizenship so that the unity and integrity of the nation can be maintained. Now, apart from this, we have the overseas citizenship of India as well, that you must have heard in news lots of time when we talk about Indian diaspora that is living outside India. Now, OCI was introduced and established by Citizenship Amendment Act of 2005. Over here, any person who is person of Indian origin, let me tell you now, earlier there were 2 different cards, or there were 2 different types of benefits that were given to the OCI and the PIOs, that is overseas citizen of India and the person of Indian origin, but now both of them had been merged. So the eligibility criteria is that he should be person of Indian origin, or spouse of Indian citizen, or the child of OCI holder. Alright, over here the OCI cards are not provided to Pakistan and Bangladesh citizens. Please remember this. Alright, what are the benefits when a person gets the OCI card? He gets lifelong visa free entry, alright, and multiple entries. He gets the property ownership rights, alright, except the agriculture property. He cannot or she cannot have agriculture property, but otherwise he has the property ownership right. work and business rights in India, as well as educational benefits can be given to, or they are given to these OCI card holders. Now, there are limitations over here, that is, they are not provided with any voting rights, they cannot hold any public office, and also there is no government employment that could be provided to them, as well as they are not eligible for any of the constitutional posts, because all these things are given to the citizen of India. Now, although there is a term citizenship, overseas citizenship of India, actually OCI is not the citizenship of India, because we do not have dual citizenship and we do not permit the dual citizenship in India. India does not recognize dual citizenship. Why? Because of the security concern. There are questions of loyalty and national security when we talk about the conflicts or during the conflicts. Alright, along with this, there are administrative issues, there are complexity in managing dual allegiance as well as legal jurisdiction, and we have given the alternative, that is OCI, that gives the limited rights to these people without full citizenship status in India. Now, over here, when we talk about the constitutional philosophy, we have already covered preamble, which starts with "We, the people of India." Over here, the word citizen reflects the collective sovereignty or the popular sovereignty that we have studied and the democratic foundation, and it reflects the core principles that are there, that is the unity, equality, as well as fraternity. So that is why we have single citizenship in India. Now, there had been recent developments when it comes to the citizenship of India, and that was when there was Citizenship Amendment Act of the 2019 that was brought. Alright, this Citizenship Amendment Act or CAA 2019, alright, that was brought. It gave or granted citizenship to the persecuted religious communities or minorities, that is Hindus, Sikh, Buddhist, Jain, Parsis and Christian, which are from Pakistan, Bangladesh and Afghanistan, who entered India before 31st December 2014. Over here, let me tell you what was given over here. What was given over here is that when we talk about these people who are coming from Pakistan or Bangladesh or Afghanistan, they can be citizen of India, but by the process of naturalization. Alright, however, they were given the process to register as the citizen by the process of registration. Alright, so that is what was given over here when we are talking about CAA or Citizenship Amendment Act of 2019. But there was a controversy because it was criticized for excluding Muslims and the concerns about constitutional validity under Article 14, that is equality before law. Alright, but when we are talking about over here, so this had been provided for those persecuted minorities which are in the neighboring nations, whether it is Bangladesh, whether it is Pakistan or the Afghanistan, and they must have entered before the 31st December 2014. And there is NRC debate as well. NRC is basically National Register for Citizen or of Citizen. So over here, citizenship verification exercises implementation had been done in Assam, and there is debate that this National Register of Citizens should be maintained all over India, and nationwide implementation had been debatable in the recent times. So these are certain things that you have to look forward in the news. If you find any news articles over them, then it is important for your upcoming examination. Now, when we are talking about UPSC examination, it focuses on the constitutional provisions from Article 5 to 11, as well as historical context of the participation, the 5 modes through which there is acquisition of the citizenship, as well as 3 modes of termination of the citizenship, statutory framework where we are talking about the Citizenship Act of 1955 and the recent developments or the amendments that are done, as well as single citizenship concept where you have to compare it with the USA federal citizenship model, as well as the rationale and the benefits, as well as the contemporary issues you have to cover, like we have NRC, we have OCI status, we have dual citizenship debate, as well as Citizenship Amendment Act of 2019. Alright, so over here you can see the comparative analysis between India and USA citizenship. In India we have single citizenship and it is on the basis of domicile as well as law. All right, this is given or regulated, or the amendment to the citizenship can be done only by the parliament. And over here in India, there is no dual citizenship that is permitted, and we have overseas citizenship, that is we have given limited rights to the OCI or overseas citizenship of India. All right, and we have the philosophy of equality and unity when it comes to citizenship. In USA, there are dual citizenship, that is there is a single, there is separate citizenship for the state and for the center, and there is the birthright, or just solely that is basically the basis of granting the citizenship in USA. It is by the constitution that the citizenship is provided or amended, and there is dual citizenship that is permitted in USA, where a person can have the citizenship of any other nation as well. There is full dual citizenship possible in the USA, and the basis of it, or you can say the philosophy of giving the dual citizenship in USA is federalism. All right. So that would be all, but moving ahead, these are certain questions that you have to answer for checking your knowledge. All right, under which article can Parliament make laws regulating citizenship? Very easy. All right, what are the 5 modes of acquiring citizenship in India under Citizenship Act of 1955? Can India have dual citizenship? What is the alternative that has been provided? Which religious minorities are eligible for citizenship under CAA 2019, and from which countries? So these all things will help you in revising what we have studied so far, and whether you have gained something from this session. All right, so that would be all in this session in Polity in 20 minutes. We'll meet again with another session. Until then, take care of yourself. अपना ध्यान रखिए, सुरक्षित रहें. साथ ही साथ do not forget to like, share and subscribe to our channel for more such updates for the polity. Thank you. Bye-bye. Take care and Jai Hind.